Appeal in the matter of Gotti and Perrett.
Yes, Mr. Hurst.
Good morning, lady. Good morning, my lords. I appear this morning on behalf of Mr. Gotti, the appellant, in an appeal for which permission was given by Lord Justice Lewison. I appear instructed by JN Statute Solicitors, representing Mrs. Perrett, the respondent, Mr. Eardley, King's Counsel, and Mr. Mitchell. The Council discussed an allocation of time, and with your leave, I propose to speak until 12:30, and then Mr. Eardley until 2:30, with some time thereafter for questions.
Yes, certainly. We've had an opportunity of reading all the papers. Obviously, it's outlined the judgments, looked at the orders, and dipped into the authorities. So I think you can take it that we're each of us familiar with the case.
We're grateful for that.
So we certainly did not envisage the matter taking all day. So it seems like you agree with us.
Yes, indeed. If I can start by just a short introduction and overview of the appeal, and then launch into my two rounds of appeal. In issue of this second appeal is what are the powers and jurisdiction of the county court in a dispute where an inter-injunction is obtained, no claim form issued, and the case injunction voluntarily abandoned by a claimant. Does the court have the full panoply of CPR powers at its disposal to case manage litigation in the usual way, as the respondent contends that the courts below have determined that it does? Or are the protocol exchanges, omission to serve a claim form, abandonment of a claim, and the grant and discharge of an inter-injunction without more, events which merely precede the court being seized of proceedings at all, whether under statute or the CPR, as the appellant contends, with the result that there is a dispute in which the court is involved, but falling short of proceedings? And are these events insufficient to give the court jurisdiction to progress the litigation further? The appellant says that that result is reached by straightforward interpretation and application of statutory and CPR provisions and relevant case law, and which, as a matter of first impression, may appear an affront to common sense, but on closer analysis is not. Whatever the court thinks of this case and what has happened in Worcester County Court in August of 2023, and particularly the conduct of my client in pursuing the dispute, which he has accepted since March 2024 was deeply misconceived, the case presents an opportunity for the court to clarify these important issues. The appellant has three core arguments. First, the circuit judge erred in determining that statutory provisions under the County Court Act 1984 and the Senior Courts Act gave the county court jurisdiction in this case under statute. The second alternative determination by the circuit judge was that if that was not right, then CPR 3.10 could be relied upon to overcome the fact that there was no issued claim form in favour of converting a form N16A, a general form for an application for an injunction, into a claim form was also wrong as a matter of law. And then the third proposition of the appellant on this appeal is that the circuit judge and the deputy district judge before him both erred in failing to address the true position that obtains in this case, namely that there were no proceedings started before the court, and as a corollary, the court has no jurisdiction to continue to case manage the dispute between the parties. Accordingly, this court should set aside the orders made by the deputy district judge and circuit judge below, save for the order discharging the injunction. This third proposition of the appellant, that the court has no jurisdiction in the strict sense, is the correct position when the facts in the case are examined from a number of different angles, we say. There is only a jurisdiction based on statute if the CPR prescribes that there is, and the correct application of the relevant provisions of the CPR produce a result that there is not. The principle has been established several times in various cases on when the costs jurisdiction under 44.2 arises. None of the exceptional pre-issue jurisdictions under the CPR for disclosure, for inspection of property, or to grant urgency emergency injunctions apply in this case. The indicted jurisdiction to grant and also to discharge an interim injunction where the parties were properly before the court, as they were here, did not lead, in my submission, to a once and for all jurisdiction. Something further had to happen administratively under the rules for matters to progress beyond the obtaining of that injunction, and that did not happen in this case. Lastly, I will address the fact that this case, understandably, as it has in the two courts below, generated some considerable sympathy for the position of Mrs. Perrett, as no injunction should have been granted. But however deserving the case, and the appellant accepts that a series of serious mistakes were made and the claim was abandoned, that for several months, and an injunction had been maintained for several months, contrary to
7 months, wasn't it?
It was 7 months. Contrary to Mrs. Perrett's interests. No sympathy factor should, however, disturb the rational operation of the relevant CPR rules. There were, I shall end by submitting a number of ways in which the respondent could have discharged the injunction in very short order that are consistent with the interpretation of the CPR that the appellant...
But that's paragraph 56 of your skeleton. Paragraph 56.
Yes, that's right.
We've read that.
I'm sorry?
We've read that.
You read it, yes. Yeah, I'm not going to spend any time on that. The first ground of appeal, the circuit judge erred in holding that the correct interpretation of applicable proceedings of the county court meant that the county court was seized of proceedings. The judge based his decision on the statutory provisions providing a complete answer to the question of jurisdiction. The appellant's case is that was an error that the CPR applies and in effect overrides. It is not in dispute that the county court had the power to grant the interim injunction. You'll find section 38 at tab 31 of the authorities bundle. And it's at page 607. And it provides that the county court may make any order which could be made in the High Court if the proceedings in the High Court, and that order may be final or interlocutory, and that is the basis for the grant of an interim injunction in the county court. The High Court has a discretionary jurisdiction under section 37 of the Senior Courts Act, which is found at page 619 in the authorities. The High Court may, by order, whether interlocutory, final, grant an injunction or appoint a receiver in all cases in which it appears.
Page 609.
Sorry, 619.
Thank you.
619.
Thank you.
In where it appears to the court to be just and convenient to do so. So by the root of those two statutory provisions, the High Court had jurisdiction to make an interim injunction. That question was not an issue before the Deputy District Judge or Circuit Judge. If I can ask you to see the submissions that were made below. Just to look at one paragraph of them, which the reference for that is page 139 of the core bundle. And you'll see it. It's headed supplemental submissions it's a document that was submitted to the appeal before the circuit judge. And it says C does not dispute that the court has the jurisdiction to make and discharge the interim injunction.
Paragraph? Oh gosh, paragraph 1.
Sorry, paragraphs 1 and 2. Yeah. The High Court has the jurisdiction. That jurisdiction is conferred. And then I think this is where some confusion may arise from my adoption of terminology. C submits that whilst the court has jurisdiction to hear the injunction application, it did not have jurisdiction to grant it, i.e. in substance, a defamation law claim. The Protection from Harassment Act does not apply where a claimant is another jurisdiction.
What I understand you to have meant by that is, as you say in paragraph 29 of your skeleton, the court undoubtedly, having been moved by your client,
Yes.
had the power to make the order that he did.
Yes.
So it was an order that bound Miss Perrett until it was set aside.
Yes.
But you're actually saying, what you're really saying in the second half of what you just cited to us, is that for a number of reasons, an order should not have been made.
Yes, that's right.
But the order that was made was effective and valid.
I'm sorry.
The order that was made was effective and valid.
Yes. Yes, it's just it shouldn't have been made. It's the point that arises. I mean, the point is made validly in the respondent skeleton argument, and it's the point that Lord Scott, or Foscott, alludes to in Fourie and LaRue, which is the mislabeling or the lack of precise terminology about jurisdiction. So jurisdiction in the strict sense, the court has the jurisdiction because the parties are properly before it to make the order, but should not have exercised that jurisdiction in accordance with its established practices and procedural law, etc. We say that is the position here, that it was obtained, it was a proper order, it should not have been obtained, but it was because of a perfect storm of various factors, which I'll come on to in due course, but which will be very obvious to the court from reading in. So the appellant accepts that the county court always had jurisdiction in the strict sense to make the injunction, but just so that the appellant has properly nailed its colours to the mast on this point, what he's submitting is that what was really always an issue in this appeal has nothing to do with the grant of the interim injunction or the jurisdiction for that, but has everything to do with whether the court, and I believe this is Lord Justice Stuart-Smith's point, the court, but has everything to do with the whether there is jurisdiction in the strict sense, since the time that the claim form should have been issued. CPR 24 practice direction, which existed, CPR 25 practice direction rather, which existed at the time, provides that the claim form must by undertaking be issued on the same or next working day. As you'll know, the practice direction has changed in that it's disappeared, but what was in force at the time is at tab 36 of the authorities bundle. And you'll see if you look at paragraph 5.5, of the practice direction. Sorry, that's an erroneous reference, so I need to check that. Yeah, it's 5.14. Yes, 5.15.
Yeah.
So, so the obviously the claim form by undertaking ought to have been issued on the hearing, and the date of the order related to loss was the 3rd of August 2023. So it's on the 4th of August, since the 4th of August 2023.
Has the practice direction been replaced?
No, that came in April. So the new version of CPR 25 dates from this April.
And is it different in its substance in relation to this part?
It's not. In that what it does is it promotes. It simply moves into the rules all matters that were previously in the practice direction. It's synthesising. It's not.
Okay.
It's not reformative.
Thank you. No, that's helpful.
So what this appellant is saying is that whether the statutory provisions and rules allow the court simply after grant of interim injunction without more to entertain and case manage a claim in the normal way, i.e. full fat CPR, if I can call it that very colloquially, using the case management powers under CPR 3 and Part 23 and all of the rest. The respondent brought, and this is at page 275 supplemental, the respondent proceeded on the basis that that was the position, and this is the apart from the filing of some further evidence in support of the injunction, which isn't in the bundle and you don't need to be troubled by, but which simply asks for it to be continued for similar reasons. Apart from that, the next step that was taken in terms of a filing of the in the case was the application of the respondent. And as you can see, it's a wide-ranging application for various forms of relief, but it's undoubtedly an application which requires the case management powers of the court and assumes them to be in play.
Do you accept that they are?
No, I mean that's the root of this.
Is it your case that the application notice could not properly be issued? A substantive application.
The
I know you say in
application.
paragraph 56 there are other more economical ways of dealing with it, but each of them involves doing something in relation to the court to move the court to
Yes.
have this aside.
Yes.
And is it your submission that those steps, whether the steps you suggest under 56 or adopting the approach here, were illegitimate in the sense that there was no power for the court to respond to them?
That's correct.
No power in the court to respond.
Well.
So if the respondent had adopted one of your suggested routes,
Yes.
no power in the court to respond to them, no power in the court to set aside the injunction, no power what?
The court it must be the case that the respondent could have had resort to the things that are in part that are mentioned in the skeleton argument. There's an injunction based upon invalid service, which must by definition jurisdiction. Sorry, there's a jurisdiction challenge under CPR 11. Which is conventionally used for any. This is from Hodinot and Sim and Holmes onwards. That's the jurisdiction which is conventionally used for the court to declare that it doesn't have jurisdiction because there hasn't been service. Now, a fortiori, if there's been invalid service through misservice, there must also be invalid service because there's no originating process.
I'm very sorry, I don't understand this.
I'm afraid I'm not following either.
Can I just see? Can we just test this? As it happens, no return date was fixed,
Yes.
but it might have been.
Yes.
And say they'd fixed it for the following Monday,
Yes.
and Miss Perrett had turned up with lawyers having incurred costs, and the court had set aside the injunction.
Yes.
Is it your submission that in those circumstances Miss Perrett would not have been entitled to any costs? Sorry, let me phrase it better. Is it your submission that the court in those circumstances would have had no power to award her costs?
That does appear to be a position on the law, and that is my submission.
Really?
That is your position. No claim form's been issued.
No claim form. I'm going to obviously go to everything, if you permit me to. Would you like to go to that now, or?
Well, and I'm just trying to understand the full consequences of what you're saying.
So if an injunction's made,
Yes.
and please, because you've been extremely frank with the court and said you understand completely the unattractive aspects of your case, but you're arguing a point of pure law, and we completely respect that.
Yes.
All right. But the corollary, as pointed out by my lord, is that an injunction was made which should never have been made,
Yes.
if after a very short period of time, 48 hours or something,
Yes.
the person against whom that injunction had been improperly made came before the court,
Yes.
having incurred the cost of getting legal representation, who'd
Yes.
said to her, whoa, whoa, just a moment, this injunction should never have been made.
Yes.
You must go before the court immediately and
Yes.
get it discharged.
Yes.
And so they go to court
Yes.
48 hours later, but before the claim form's been issued,
Yes.
because the person who got the improper injunction has not complied with the rules to
Yes.
file such a claim form, that the judge had no power in discharging the improperly made injunction to make an order for costs.
That appears to follow from the authorities that deal with when the cost jurisdiction of the court comes into play. Is this a good time to go to them?
Now, I'd like to ask you another question before
Okay.
we get on to that. So just going back to, you took us helpfully to supplementary bundle 275, the N244 notice.
Yes.
So that's in February.
Yes.
So we still haven't got a claim form
No.
issued at that stage, as
Yeah.
we're aware.
Yes.
And they seek for the injunction to be revoked and all those other matters.
Yes.
I think that your case is that the judge, when this was put for a judge, the judge in law should have simply said, I have no power to deal with any of these
Yes.
applications, go away.
That's what we told him. That was the position before the Deputy District
Yeah,
Judge.
well, I'm conscious that's how it was put,
Yes.
but I want to see now, a long way down the line in the Court of Appeal,
Yes.
that's your case remains, that's what the judge should have done.
Yes, our case hasn't changed since we were before the Deputy District Judge. It was obviously argued more fully before the Circuit Judge and him. So there were two points of appeal. One is that the wording of the statutes doesn't provide a jurisdictional basis, and that argument is as follows. Section 38 and the interim injunction are a red herring. There is jurisdiction for Broad Idea and Fourie LaRue are authorities for the propositions that if parties can be properly brought before the court through being served with notice of an interim injunction application, that it is not a prerequisite at that stage for there to be proceedings issued, and there are, as the Supreme Court has and the Passport Court has said, that the evolving nature of the equity jurisdiction to make interim injunctions from Morava to Norwich Pharmacal to internet IP blocking doesn't in many scenarios involve the necessity of there being a claim in the background. So that's obviously the position of the interim injunction. The County Court Circuit Judge said that one starts with section 38. In fact, we say that was wrong. It's section 15 of the County Courts Act, which must be relevant where matters go beyond the injunction, and that is at that is found in the authorities at page 606, tab 31. Section 15 is entitled General Jurisdiction in Actions of Contract and Tort, and subject to subsection 2, which concerns what it can't hear. County Court shall have jurisdiction to hear and determine any action founded on contract or tort. Civil harassment is a statutory tort under sections 1 to 3 of the Protection from Harassment Act 1997. The County Court routinely determines harassment disputes and has done since 1997. Where an action, what an action amounts to under the County Courts Act, and what we're concerned with here for the jurisdiction is an action, is defined in 147, the interpretation section, which is at pages 613 and 14 of the bundle. And that provides subsection 1. In this Act, unless the context otherwise requires, page 613, action means any proceedings in a county court which may be commenced as prescribed by plaint. Plaint is not defined in the interpretation section, and it's an obsolete term abandoned by the CPR, but it's not disputed between the parties. Means the cause for which a claimant obtained a writ or summons. Stroud's definition is in the bundle at page 645, and I read, a plaint is the process by which the proceedings in the county court are generally commenced. There are a few exceptions otherwise provided for which to commence by petition. The CPR abandons terminology of writs and summons and so forth in favour of the concept of a claim form or an application notice. As prescribed in the county court context is defined in subsection 1, midway down page 614. Prescribed means prescribed by rules of court. The applicable rules of court in the county court are the civil procedure rules. That's provided for by section 1.1 of the Civil Procedure Act 1997. If the county court once had its own rules, it has not done so since that time. CPR 2.1 provides that these rules apply to all proceedings in the county court, the High Court, the Civil Division of the Court of Appeal. Page 34. So that's why I put. Thus, there is a jurisdiction for a tort action in the county court which has been commenced by originating process as prescribed by the civil procedure rules. Whether what was before the county court was an action, was proceedings, or was a matter, all terms that appear in the interpretation section, but its action is the relevant one because it's section 15. It must be commenced as prescribed. This action, in this case, in Worcester County Court, was commenced by form N16A, the general form for an application, and you'll find the copy of that document at page 169, supplemental. And you'll see it's a perfunctory form which appears largely to function. It bears a seal, but it could indeed have a claim number, but this one doesn't. And it is, as I understand it, used as much as a notification that an application has been will be heard at a particular time. As you see, the court fills in the addresses almost like a summons to the defendant, fills in the details at the bottom to confirm that. The CPR does not prescribe this form as originating process for an action under the Protection from Harassment Act 1997. The appellant's application was under section 3. If I can ask you to just, in the same bundle, look at page 203. And you'll see this. This is the Skelton argument that was presented to District Judge Khan on the 3rd of August. And counsel begins, the case of Emerson Developments and Avery is ready support for the proposition the company may seek interim and final injunction relief under section 3 of the Protection from Harassment Act on behalf of its employees. In this case, the claimant, a director of Signature Medical, brings the application. So it is an application made under section 3. CPR 65 applies to a variety of harassment type statutory causes of action. And Rule 6528 is relevant. So 6528(1) claims under Section 3 of the
Sorry, just a
1997
moment,
Act.
65.
2238, 6528(1). It's the practice direction that deals with antisocial behaviour and harassment rules of court for those types of dispute. A claim under Section 3 shall be brought to...
Sorry, Mr. Hurst, I'm behind you. Can you
Sorry.
just hold on a sec? 2238.
Yeah, sorry, it's page 2238, my lord.
Thank you so much.
A claim under Section 3 of the 97 Act shall be subject to the Part A procedure. Part A procedure has its own claim form, as is well known, Form N208. The guidance in the White Book commentary immediately below the provision that you have open suggests it is mandatory. The guidance is to the effect, one effect of this is the claim must be issued in Form N208. CPR 65 has a practice direction, and that also supports that disputes under Protection from Harassment Act 97 require a claim form. That is found at page 2254 of the current White Book. And you'll see that Part 5 of the practice direction deals with proceedings under the Protection from Harassment Act. And the words used is starting the claim, not application, but claim. In the county court, a claim under Rule 6528, which, as we've seen, is for under Part 3 of Section 3 of the Act, will be issued in the county court hearing centre where the claim is commenced and then sent to the county court hearing centre. This is obviously a provision to do with defendant's home court type problem. But I draw it to your attention because it's strongly suggestive that what has to happen if you move the court for a protection from harassment injunction under Section 3 of the Act is that a claim, the language here is obviously at CPR 7.2, it's about commencement of a claim. The practice direction, it is true, contemplates other antisocial behaviour applications to which the practice CPR 65 applies using Form N16A, and you'll see that in paragraph 1.1, for example, which deals with Housing Act, Policing and Crime Act, Antisocial Behaviour Crime and Policing Act. That's on page 2249. So as you can see, perhaps somewhat inconsistently, Form N16 shall be treated as the Part 8 claim form, where a series of other applications are involved. But the drafters have provided a wholly different regime for claims under harassment. One can speculate, and I'm afraid I haven't been able to find any material that explains, that goes to why this may be so. My submission is that it may have been thought necessary, dealing with an act that provides for the granting of prohibitory injunctions based on conduct over necessarily a period of time, because the key concept in harassment law is the course of conduct, which almost invariably is events over months and sometimes years.
Well, I think antisocial behaviour often is also, isn't it?
I'd
Very
understood
rarely that it's a
antisocial.
one-off.
Yes, I'd heard the loud student party, perhaps on a couple of weekends running, could be essentially a more limited. I don't know. I'm afraid I haven't researched airspace. I can't help with that.
But one of your points was that the former N16A couldn't be used to in this way because it doesn't, for example, have the date or the statement of truth and other important components.
Yes,
yet
absolutely.
The practice direction appears to contemplate it being used for precisely this purpose.
Yes, it does. I mean, I'm in the middle of submitting, making submissions which are, I accept, entirely speculative, and I regret, and I believe it's the same on the other side. We've not put before the court the whole edifice of the position on these other antisocial behaviour orders. It may be that there is some creeping misinformation around how these different applications in the same practice direction might be treated. That I accept. But when one actually looks at the black letter of what's there, it's clear that there's a distinction. And I'm suggesting that the harassment cases, in general, may be concerned with a greater amount of evidence. I mean, remember the N208 functions as giving particulars of claim, which this N16 form does not. It is in no regards to be thought of as a claim form. It lacks, as my lord I think is pointing out, it lacks any of the essential features. It doesn't even have a date. And as I'm going to go on to submit, all manner of chaos proceeds if it's to be treated as a originating process. What I would also say about the nature of the proceedings under Section 3 of the Protection from Harassment Act is that they do, of course, they are prohibitory injunctions, serious ones, because they attach powers of arrest, which can be triggered if they're breached. So it may have been thought that having a better system of notice and particularisation of what the foundational claim was desirable. And then lastly, the rules of court do of course prescribe very specifically when there are proceedings before a civil court, because CPR 7.2 provides that proceedings are started when the court issues a claim form at the request of a claimant. The act of commencement is defined, if I can ask you to look at 7.2. The claim form is issued on the date entered on the form by the court. So that's the signifier of the date of commencement of proceedings. Therefore, my submission is that whether there is an action before the county court is reliant on one having been commenced in accordance with the CPR. And what was done in this case would not act sufficient to commence a civil harassment claim under the relevant CPR provisions, as no claim under Section 3 of the Protection and Harassment Act was commenced using N208 issued by the court as per CPR 7.2. What was done was simply not prescribed in the language of the County Court Act that we've seen. In terms of the meaning of proceedings, the CPR, the word proceedings, the CPR and the County Court Act both do in fact distinguish between things which are before the court, which are not proceedings because they take place before proceedings are started. You've got CPR 7.2 open. You'll see that 7.22 provides that a person who seeks a remedy before proceedings are started must issue an application under CPR 23.
Sorry, which provision was that?
It's in Rule 7.22. So the foundational rule is in effect, in my submission, distinguishing between an application, which may come before, and proceedings, which are generated by the issue of a claim form. Now, I accept, and it will be obviously said by the respondents' team, that the CPR is not consistent in this, and I submit that in some ways it would be possibly more desirable definitionally if things that were before commencement of an action were called applications consistently, and matters and disputes that where there'd been issued a claim form called claims or proceedings. I think, but that isn't the case, and I'm not going to pretend it is. But there are myriad, and I'm just going to briefly note them. There are myriad references in the CPR and also in the County Court Act that do distinguish between where the court is dealing with a dispute or an application, but it isn't proceedings. Proceedings haven't commenced. So section 52, and this is in tab 31 of the bundle at page 611, deals with powers of the county court exercisable before the commencement of an action.
Sorry, could you just give the page number?
611. So on the application of any person in accordance with rules of court, county court shall in such circumstances as may be prescribed have power to make an order. So this is an inspection power of property and such like, which may become the subject of subsequent proceedings. And then below that you'll find on an application in accordance with rules of court. This is essentially the pre-action disclosure jurisdiction, which also exists in CPR at 31:16. At 31:16, if I may invite you to just quickly turn it up, is also another provision that makes the before and after reasonably clear. Disclosure before proceedings start. The rule applies, page 965. The rule applies where an application is made to the court under any act for disclosure before proceedings have started. And CPR 25.21, which deals with injunctions.
25.21.
Yeah, 25.21, which is at page 708. An order for an interim remedy may be made at any time, including before proceedings have started. And then CPR 25.2, the court may grant an interim remedy before a claim has been started, only if the matter is urgent or if it's otherwise desirable to do so in the interest of justice. This is not an exhaustive list, but my submission is that the CPR and the County Court Act do differentiate between an action or proceedings which must be commenced by claim form and something which may occur before that, which some, but not all, provisions refer to as an application. The position of the circuit judge and the respondent is that anything brought before the court at any time amounts to proceedings to which the CPR should apply. The cost jurisdiction cases, a bright line regarding when the court has jurisdiction and when it does not, is the position which a number of decisions of the High Court have arrived at, when the issue has been one of when the jurisdiction on inter partes costs between the parties arises. If I can ask you to look at citation and Ellis, citation PLC and Ellis to start with, which is at tab 12 of the authorities bundle.
At 30.
Thank you. Sorry, 13. In this case, Mr. Justice Tugendhat was concerned with, as you see at paragraph 7, to identify the basis of the court's jurisdiction to make an order for the payment of costs before the issue of the claim form. There was an issue in the case as to recovery of the protocol-based costs. And you'll see that at paragraph 14 of his judgment, over the page, at 196, he encapsulates reasonably neatly the facts of this case. CPR does not expressly address the situation where a claimant has good grounds for intimating a claim, but there is no agreement between the parties, and before the claim form has been issued, it becomes clear that whatever factual basis may originally have existed for the claimant's claim, if any, that factual basis no longer subsists. Now, we accept that what seemed like good grounds at the time on contact with reality turned out not to be the case. But the nature of the problem, in my submission, is sitting there in paragraph 14 of Mr. Justice Tugendhat. In dealing with the problem of whether the protocol costs could be recoverable in this case, he relied, as you can see it from 15, on the decision of Lord Coulson, as it then was in McGlynn, and a case called Roundstone Nurseries. And what that finds in shorthand is that Section 51 of the Supreme Court Act, which reads, subject to the provisions of this or any other enactment to rules of court, the costs of and incidental to the proceedings in the High Court should be at the discretion of the court. So what the case is, what Roundstone, building upon Gibson settlement trusts, decides is that the incidentality extends to protocol costs, but they become recoverable. The trigger point is the commencement of a claim. And he reaches that conclusion at 16 over the page, where he says, in summary, I take the law to be, if no claim form is issued, there is no litigation. And so there are no costs of litigation, whatever costs may have been incurred in complying with the protocol. But if a claim form is issued, the costs incurred may become recoverable as incidental.
But that's not this case.
No.
Because what's being spoken about there is where, although the pre-action protocol procedure is followed,
yes,
nothing happens to move the court
that's
using.
Right.
Well, that's not this case.
No, that's right. That's right. But but in terms of the principle it decides, it's a before and after principle. In that
But we're concerned with costs incurred as a consequence of moving the court. We're not concerned with costs involved, not incidental to moving the court.
But my answer to that is that this is a construction of the jurisdiction in which costs arise in the county court and the high court, and this case is one of a whole line of cases. It's been, I mean, it starts obviously with the ones that you can see here. It starts with Roundhouse. It starts with Sir Robert McGarry in 1981. But you've got a long line of cases
Which say, forgive me, which says that if you incur costs, but in fact you never get to court, those costs are not recoverable.
Yes, but is
Right.
there?
What's that got to do with us?
But is there any principled distinction? I mean, the involvement of the court is a fact, but is it a sufficient fact to take it beyond the principles which are here? Which is that you may have a much more expensive pre-action protocol phase. I'm sure in many commercial disputes that are resolved without the court becoming involved, the pre-action protocol and the Webb case is a very good example of that, which is in the Webb case there was a claim for about 30,000. There was an extended. This is at 16 of your bundle. It's the next one in. It's the next cost case in time, and there was a pro-neg action in relation to a developer, I think, and there was a claim of, you can see it, paragraph 7, of the value of 31,000. There was a 2-year period of negotiations in which, before the claim was issued. The claim is then issued at paragraph 9 in 2013. The dispute starts in 2011, as you can see from paragraph 7. Letter of claim dated 2011. Dispute still not resolved 2013. A claim form is issued, and then but after that the claimant backs off. He, like the claimant in this case, he effectively abandons his position.
And it's not like the claims in this case, isn't it? Because the claims in this case went to court.
Well, but that's the yes, but that's right.
And obtained an order.
Yes. I'm not saying it's not a factual distinction. I'm just saying that the way that the costs jurisdiction has been analysed, it would fall on the side of the line of pre-action protocol costs. And I suggested then to Lord Justice Stuart-Smith that the costs of pre-action protocols might be significantly greater than the costs of moving the court for an hour on a August afternoon. I accept that the optics are obviously completely different.
I don't think it's just a matter of optics. I mean, it's a matter of you've gone to court and you've got an injunction. And it's
yes.
a fundamental impact on someone's life.
Yes. But my client
resolving a case
yes.
by negotiation, albeit expensive negotiation, has avoided the necessity to go to court.
Yes.
It doesn't help me you saying it can be more expensive to negotiate and avoid court than go along, as you say, on a August afternoon for an hour.
I take your lady's point. I'm not trying to belittle what happened here, and I've been at pains in my documents and my submissions to accept that this was deeply misconceived, ought not to have happened, and that it is obviously in the factual matrix here that Mrs. Perrett was subjected to something she shouldn't have been. But
I think I've already indicated I completely respect and I'm grateful for your approach, because it makes it much easier for us to focus on the point of law.
yes,
But equally, I'm not, for the point I was making, concerned about the facts of this case.
no, yes,
The thing I want to test with you is your submission that really there's no difference in the approach and principle, whether you go to court and get a prohibitive order made against you, or whether you successfully negotiate without having to go to court. I'm struggling with that.
yes. All what I can offer in that regard is that my client has put forward the law as it finds it, and it applies to the facts.
Well, you're saying by analogy it should.
Yes, but it's by analogy.
You're saying it shouldn't matter whether you have to go to court or not. If a claim form's not being issued, that's that.
My submission, my lady, is that what these cost cases are doing is they're actually deciding really the point that's at large in this case, which is the jurisdiction of the CPR, because there's no, if they're right, if these cost cases are right, what they're saying is that section 44, which gives the court discretion on costs, is not activated until the claim form has been issued. That's as you've just seen from. I mean, it's academic where they go afterwards. They don't depart from what you've seen in the decision of Mr. Justice Tugendhat and his summary. That's applied. The cases are in the bundle. There's one called Stubbins. There are two of Master Nurse. They all proceed on the same basis. I mean, in the one that you've got open, you'll see at Perrett page 226, page 34, you'll see that the costs master's view on this. He ends up saying, I agree with Mr. Justice Tugendhat's analysis. What is clear is that the issue of the claim fundamentally changes the position. But what my submission about why these cost cases are important, and they're, as I say, they're all at High Court level as far as I'm aware, is that what really the application of the CPR that they are deciding is in substance no different from the position that I have been urging on the Deputy District Judge and the courts in this case. What is the difference in principle between CPR 44.2 being in play and CPR 3 being in play, or CPR 23, or these rules being in play? And I'm fortified in the submission by what is said about CPR 3 in a number of other cases. Essentially, it's the same principle is rolled out. If I can just take you to them, I should just incidentally add just one small detail point on the cost point. The cost point which is reached here in the authorities evolving to, I suppose Mr. Justice Tugendhat is suggesting to occupy a lacuna on what should happen, is reflected in the rules by the committee. CPR 36 has exactly this bifurcation sitting at its centre, and what that amounts to is that, as we all know, a CPR 36 offer can be made before commencement of proceedings. CPR 36.5, for example, where is this? That's on page. Yes, 36.5. CPR 36 offers can be made before commencement of proceedings. However, they don't contain provisions as to their costs, because the costs entitlements are triggered by acceptance either during proceedings or failures to accept post judgment, which is dealt with in Rules 36.13 and 36.17. The position where there are no proceedings is different, as you can see at 36.13.1. So 36.13.1 is found on page 1173. And you'll see that what's happened here is that so it's where a Part 36 is offered, its offer is accepted within the relevant period, the claimant will be entitled to the costs of the proceedings, and then in brackets, including their recoverable pre-action costs, up to the date on which notice of acceptance was served on the offeror. Now, that is there because an offer of a Part 36 offer before proceedings commence has no deemed consequences as it would do after proceedings have commenced. And you'll see that at 44.9.2. So that's on page 1415 of the White Book. And that says costs where cases where cost orders deemed to have been made, subject to paragraph 2, where a right to costs arises under Rule 36.13.1 or 2, claimants entitled to costs where Part 36 offer is accepted.
What are you looking at?
Oh, sorry, I've looked at the wrong thing. I do apologise. 44.9.2. Sorry, I was reading you 44.9.1.
44.9.2.
44.9.2. So right, so
Page.
Sorry, 11415.
91415.
It should say It should deal with deemed cost orders, 44.9.
Okay. And then on to the
Right, so 1B has the provision where there are deemed costs orders on acceptance of Part 36, and 44.2 takes that away where there are no proceedings issued. So the CPR reflects the position that I've shown you in the authorities. The CPR 3 cases reach a similar decision. You'll find in the bundle Peterson and De Walden, which is a recent decision of Mr. Justice Eyre in the King's Bench, and this was concerned with whether case management powers applied when to fix the problem under CPR 310 could apply when the wrong court issue fee for a claim had been made. The court rejected the claim because of the £24 was the amount at stake. The court rejected it. You'll see this at paragraphs 16 and 17 on page 475. Court rejects it. It's not issued in time. Then paragraph 21, the recorder was then invited to make an order applying to CPR 3.10 to validate a step taken from presenting the Part 8 claim form in the manner in which it was presented, i.e. to excuse the fees issue. The claimant, the rule, CPR rule 3.10 provides that where there's been an error of procedure, such as a failure to comply with the rule of practice direction, the court may make an order to remedy the error. The recorder, Hanson, who looked at it first instance, you'll see it paragraph 23, he accepted, I agree with counsel for the defendant, that it is the issue of the claim form that marks the commencement of the proceedings. That is only then that the court's case management powers under 3.10 are engaged. And the claimant in Peterson then went on to contend that CPR 32, the procedure for the purposes of CPR 32, this is at paragraph 32, included any procedure, including the full issue of the claim form. Because his problem was, of course, that he was trying to remedy a failure to comply with what's effectively the EX50 civil fees notice. Relying on the fact that there were a number of rules that provided, he relies on the fact there are a number of rules that provide for applications for commencement before proceedings. This is at 32. It was argued by Mr. Peterson that because the pre-action jurisdictions exist, 3 Part 10 must apply to all procedures of whatever kind under the rules. The defendant, this is at 35 and 36 on the next page, made two relevant arguments. CPR 3.10 cannot be used to remedy compliance with the statutory requirement. And secondly, the case management powers under CPR 3 are only engaged once the proceedings have been properly commenced. You'll see that at the bottom of, she says, Miss Green, confusingly both counsel were called Green, but Miss Green was the defendant, supported the contention by referring to the context of Rule 3.10 in the CPR, namely that it's in Rule 3, which is concerned with case management powers, and that they were necessarily powers in relation to proceedings once they've been commenced. And Mr. Justice Eyre rejected the claimant's arguments, and he held at 41, firstly, that CPR 310 can't apply to an error which was made under a rule, not made under a rule or practice direction. The error in that case was the failure to comply with something made under statute, i.e. the Civil Proceedings Fees Order 2008 and the Courts Act. And then he also, at 43, went on to say, he starts by saying, sorry, I apologise, at 38, he starts by saying, as will be seen by the following analysis, I reject the claimant's interpretation of 3.10. I do so substantially for the reasons advanced by Ms. Green and by the recorder. And he goes on to say at 43, second sentence, in that regard, Ms. Green was right to point to the rules location in part 3 of the rules, and accordingly in the part of the CPR concerned with the court's case management powers. Such powers are necessarily concerned with events after proceedings have commenced, and that was his decision. The same decision was arrived at by Mrs. Justice O'Farrell, looking at 3.10 in a case called Good Law Project and Secretary of State for Health and Social Care, which is at tab 24. My lady, my lords, this was an invalid service of claim form case, and if I can take you into 41 of the and 42 of the decision, you'll see at the bottom of the previous page, paragraph 40 of the judgment, this was a case concerned with whether 3.10 could be sent into battle to remedy a service error. What had happened here is at 42, third sentence, an unsealed claim form was sent to the new proceedings address on 27th April, but that did not constitute service. There were various problems here. There was agreement in writing to proper service on a specified email address for the Secretary of State, and there was a short window of time, short limitation period. Short limitation period in which to do so under the specific act. But the claim form wasn't issued until a day later. So the same problem arose here, that CPR 3.10 is being relied upon to cure things that happened before a claim form. And Mr. Justice O'Farrell, again, on all fours with Mr. Justice Eyre, reliance on 3.10 at paragraph 45 does not assist the claimant. Although CPR 310 gives the court wide general powers to rectify errors of procedure, the rule provides that the error does not invalidate any step taken in the proceedings unless the court so orders. The power confirmed is to remedy that error. The difficulty faced by the claimant is that sending the unsealed claim form to the defendant did not constitute a step in the proceedings, because at that date there were no proceedings. And again at 52 over the page, the sending of an unsealed claim form before issue does not constitute a step in the proceedings, and the court does not have the power under 310 to correct the irregularity. That takes me to the second ground of appeal. The circuit judge had an alternative holding in this case, which was that CPR 3.10 can convert Form N16A into a claim form, and we say that he fell into error for a number of reasons. We've just seen that the application of CPR 310 is dependent on issue, so it is very hard to approaching these authorities which were cited to the circuit judge to get to the conclusion that he did. But there are other very good reasons why CPR 310 cannot be used on the facts of the present case. An error of procedure under CPR 310 refers to errors of procedure established by the CPR itself, but it cannot be used to remediate errors of compliance with permissions imposed in statutes. And the authority on that is which is cited in these cases, but it's I have it separately. It's tab 8 of the bundle of authorities. It's a case called In Re Osia Roads. It's if the facts of my case are unappealing, the facts of this one were perhaps more so. The background was that a notorious convicted mass murderer, Jeremy Bamber, who shot most of his family in a remote farmhouse in Essex in the 80s, was claiming that a family company in which he was interested was run in a way in which his interest was being prejudiced and he wasn't being paid. It's a litigant in person case, but you'll see that Mr. Justice Pumphrey on page paragraphs 1 and 2 set out the essential dispute, as I've said, that Bamber was trying to make a company, take a company to account for its affairs, a family company, and paragraph 6, paragraph 12, i.e. as that's of the pleading, appears to base the particulars of claim firmly upon the provisions of section 459 of the Companies Act, which is set out in the first paragraph. Now, in that case, a CPR 7 claim form had been used to apply for relief deemed to fall under that section 4591 of the Companies Act. The section itself required the application to be by petition, and you'll see the procedural point which was relied upon on strikeout at paragraph 12 of Mr. Justice Pumphrey. It says the procedural point is a short one. Section 4591 of the 1985 Act grants a power to a member of the company to apply to the court by petition. Mr. Bamber's proceedings were not a petition. They were proceedings by claim form accompanied by particulars of claim. So it is said these proceedings are a nullity by the family defendants. Now, he went on at 15 to say, it seems to me as a matter of construction that words error of procedure relate here to errors in the procedure established by the CPR themselves. It does not seem to me that the words are apt to relate to requirements imposed by statute, other than by statutes underlying the CPR, perhaps. But in any event, not to apply to section 4591 of the 1985 Act. Now, if you could turn to 34 of the same authorities bundle. Sorry, 33 rather. Section 3 over the page on 629 is the civil remedy in protection harassment proceedings. Section 3.1 provides that an actual that a breach or apprehended breach of section 1 may be the subject of a claim in civil proceedings by the person who is or may be the victim. And then section 3 lower down provides that an injunction restraining the defendant from pursuing any conduct amounting to harassment may be granted in such proceedings. Therefore, the civil remedy under section 3 requires a claim to be brought, which amounts to proceedings. And this is differentiated in the Act from applications. So, for example, under section 3A, which is at page 631 of the bundle, a person may apply where there's an apprehended breach, and under section 2, in such a case, any person who is a person who's a victim, of course, conduct in question, or any person falling into section 119 may apply to the High Court for an injunction restraining the relevant person. Therefore, a construction of protection from harassment 1997 puts it in the same category, I submit, as the position before Mr. Justice Pumphrey, in that the Act is saying that you need proceedings and a claim. This also, incidentally, was exactly the position of this respondent if you could turn to to page 429 of the bundle.
Authorities or
No, correct. It's a supplemental bundle.
Okay.
I'm going to get on to the facts of what the evidence shows in terms of what was issued and what wasn't issued. You'll have seen from the skeleton arguments that there were two claims, not one, unfortunately, but which were equally misconceived, but they had slightly different procedural histories. But they were brought by Mr. Gotti for the same problem, which was essentially to try and regulate what was being said, they thought, adversely to themselves on social media. And there was a respondent to a separate claim called Miss Tracy Holland, to a claim also brought in the county court at around the same time. This is a witness statement that was made in that case. The cases were, in my submission, on all fours, in that they were proceedings under the same. They were.
You say page 438.
429.
My mistake.
No, it may well be my mistake.
Thank you.
429. So this is a witness statement in essentially an identical claim that was brought to try and manage the same perceived problem at the time. It went differently, as I'll explain, in that there was a claim form and it was struck out, and some 100,000 of costs were paid in respect of it by my client. You'll see what's said by the solicitor for RPC at the time, because in that case also there was no claim form, and what was said was there's no claim form.
Sorry, what paragraph?
Sorry, paragraph 6 to 8.
Thank you.
Mr. Statue informed RPC by email that there is no claim form in respect to the application. See also his witness statement containing the same. We refer to Practice Directive 25, paragraph 5.15, which is what we saw earlier. Neither the claimant nor its representative made or offered an undertaking. Mr. Statue has said so. There's no need for a claim if the application for the injunction is not in pending proceedings. I have made a similar application at Hereford County Court, and the injunction was granted without need for a claim. The reasoning is not valid. Section 3 of the Protection from Harassment Act makes it clear that any injunction granted pursuant to that section can be done in such proceedings, referred to in section 3.1, i.e. the subject of a claim in civil proceedings. Insofar as the application injunction granted by Hereford Court is relevant, which we dispute, we would suggest it was wrongly granted. So they appear to, at that stage, agree with that point.
How does it help us that a concession that was made in a wholly different case?
Well, it's a case entirely on all fours.
It's either a good point. Your point is either a good point or it's not. And Ms. Thompson's view of the law.
Well, my point is that yes, absolutely. I mean, I'm submitting that. I'm submitting that's the case, and I'm saying, oh look what they said about it as well. But you're right, it doesn't advance matters. It's either my argument on the statute is correct or it's not. Right, the second point on 310, it's not available where a claimant does not take a step at all, rather than takes a procedural step that contains an error.
Say that again.
The principle on, Milady, the principle on 3.10 is it avails those who take a procedural step, or it can be used rather. It can be used to cure a procedural step which is taken in proceedings. What it can't do is be used to remedy a gap where no procedural step was taken at all. And I'm going to take you to the. I'm going to take you to the facts of what happened in these cases, and then to the authorities, if I may. Mr. Gotti's case is that the correct analysis of the factual background here is that this was a case in which no correct procedural step was taken at all, rather than one which contained an error. The circuit judge obviously converted Form 16A into a claim form. On the facts of this case, as part of the application to the, and I'm talking about this case, not Holland. On the facts of this case, it's page 7, supplemental bundle 173. I've taken you into the solicitor witness statement used to move the court for an interim injunction. On page 173, the last comment is I intend to make a claim against the defendant once we've calculated the financial loss. But in the interim, I desperately need the court's help to grant an injunction against the defendant. In an email to the respondent after the interim injunction had been granted, and this is on page 384, Mr. Statue said this. Finally, some housekeeping. I'm filing a form at court called an N244 notice of application and serve you with a copy. An application for an injunction should be accompanied by a claim, N208, or an application. The application for an injunction, N16A, is freestanding under the Protection from Harassment Act. But as there will be a hearing soon, cannot agree a separate case, filing of an N244 is appropriate. And he does, in fact, file an N244, and you'll see it dated it's dated 4th of July, but he files it on the same date as that correspondence. So 199 of the supplemental bundle. And it just says injunction. What order are you asking? Injunction pursuant to the Protection from Harassment Act. Then on the 7th of December, and if you turn to page 375, you'll see that the partner from RPC have now come on, been instructed and come on the record, I think in mid-November. So they're now writing, and they take the point, second paragraph. They say that threats made are particularly egregious, where it's self-evident the proper process for retaining relief and the Protection Act was not followed. And for one, our client has not been served with a claim form or particulars of claim some 4 months after the injunction was made. Now, Mr. Statue then replies to that the next day on page 497 of the bundle. You'll see he writes to RPC on the 8th of December. It's 496 is the beginning of the letter. And then on 497 over the page, he says under the heading challenging the injunction, he says at the bottom, with respect, your client or your retainer and you have had ample opportunity to challenge a very important order by way of appeal or otherwise, and yet it is only when we contend there's been a breach do you question the order. For the sake of completeness, we will file and serve N208 and N244. It was never done. It contrasts on its facts. I won't. I'll give you the references. I won't laboriously take you through the Holland case, unless you wish me to.
No.
But what happened in that case was injunction application issued 4th of September 2023. The RPC filed the witness statement that you've just looked at, that I just showed you, the Miss Thompson witness statement, October before directions hearing. Witness statement addressed reasons for the application to be dismissed. They said there's no underlying claim. And then Mr. Statue filed a response witness statement on the 1st of November, and in that he recited various arguments that he didn't think it was necessary, but then he ended up saying the appellant, that Mr. Gotti will file an N208, and that in fact happened. It was filed on the 1st of, so the claim form was filed in the other action, 1st of November 2023, but then when it was before, the district judge then struck it out in 31st of January on inter partes hearing on the merits, and then noted at the time that the claim form had been presented but not issued. And then RPC then made inquiries of the court saying, look, what's happened to the claim form to the court? And then the court responded and said, here it is, it's issued, it's attached. And that happened on the 22nd of February, 2024. So all this evidence was before the circuit judge. What we say, you don't need the Holland case, but we say that it throws it all into very stark relief. That this is what happened in this case is is that there was no procedural step taken, rather than one was taken in error. All of the evidence in this case that I've looked at is all cited by the respondents as well in their skeleton argument as to the omission of evidence. In determining that CPR 310 assists a respondent, the circuit judge relied on two cases. One is called LD Commodities Rice Merchandising, and one is called Hannigan and Hannigan. And they're both entirely distinguishable. The Hannigan is at 3 of the authorities. What happened in this case, you'll see at paragraph 7, was that this is on the cusp of transition from rules of the Supreme Court to CPR, and what had happened was that to bring a claim in the, sorry, I forgot the nature of the claim. I think it's matrimonial property after someone's died. I think it's probate related. What's happened? You'll see at 7. Is that the claimant had been told by counsel to use form N208 and had used a form with the same title from the county court, which was had become obsolete with the changeover to the CPR. And Justice Brooke notes, the proceedings were issued in this form on the 10th of June 1999. They set out the nature of the claim, the order that was being made. They stated that CPR 8 of the procedural rules applied to the claim, and they contained the evidence contained in the witness statement filed with it. So essentially, it's a totally usual use of CPR 8, but just the wrong form was used. The claimant appealed when the district judge and I think the next level of judge said, no, we've all been preparing for the Wolf reforms for years. People have got to get it right. It needs to use the right form. Lord Justice Brooke allowed the appeal at 35. He relied on CPR 310, and he says, in my judgment, the matter fell technically within CPR 310. The defendants had all the information that they required. So the Court of Appeal allows the appeal.
Read a paragraph you in, forgive me.
35 is the
Thank you so much.
Holding. LD Commodities Rice.
What was the proposition you were taking us to for in relation to that?
The proposition in relation to this is that it's distinguishable on its facts, as is the shipping case, in that what you have here is a claimant who intends to issue originating process and simply misdescribes it. But in substance, you have a claim form, and it does what a claim form should do. It appears from the facts of Hannigan and Hannigan, the only material difference was at the top of it. It said N208, and it would have had a different formatting of some sort, but the contents and purpose were the same. In terms of well, it's not a point it's a point that's implicit in Lord Justice Brooke, is that the substance and functions were there, and obviously what I'm relying on, I'm saying is, because there was intention. Obviously, it happened in this case and in the commodities case, the shipping case, is there was an intention to issue originating process. In both of them, it wasn't a question of there being two different documents that one might have to choose between. There was only one document, so it was obviously an intention to. So it's a step, and CPR 3.10 could apply because a step is taken in proceedings. It's curing a step taken rather than a step not taken. It's a dog that barked rather than doesn't bark. And the commodities case is the same. That's at tab 15, and the facts in that case were that it was a shipping claim, and the claimant had used a claim form. You'll see this is one of the bundle. An in personam claim form was used instead of an in rem claim form to commence shipping proceedings. The claim form was served out of time for an in personam claim form, but in time for an in rem claim form. But the intention of the party bringing the claim was that it was an in rem claim. The defendant challenged jurisdiction of the court, and the claimant relied, you'll see this at 18, resisted the applications and relied upon 3.10, which gives the courts a remedy areas of procedure. And at 50, Mr. Justice Tier accedes to the application to that CPR 310 can be deployed. As I've said, both of these authorities in my submission are distinguishable. There's no question that Mrs. Hannigan and Mr. Messent, who's the solicitor in the shipping case, had not sought to issue a claim form. There were in those cases no question of any alternative form of originating process to consider, and accordingly the court could be sure that CPR 10 applied. There was an error taking a step in proceedings rather than not taking one at all, which we say is this case. That is the law on that is in Boxwood and Gleeson. Boxwood and Gleeson's at 20, and at sorry, forgive me. So there's a review of the. So from 33, there's
Paragraph 33.
Paragraph 33, page 285 of the authorities bundle. There's a review of the authorities on the exercise of 3.10 with regards to all manner of claim form and service issues, and Miss Justice O'Farrell says at 46.3, in the cases cited where the power under CPR 310 was exercised, there was a relevant defective step that could be corrected. Steele and Mooney, Phillips and Nussberger, Bank of Baroda, Dory, Integral. Doubts have been expressed as to whether CPR 310 could or would be used when no relevant step was taken. There's another authority.
Where were you reading from?
I'm reading from 46.
Paragraph 46.
46.3 on page 297. There's another authority in the bundle, a Mr. Justice Nicklin case on traveller injunctions. I'm not going to trouble you with it because it just makes the same point, and it will take up time. But that was a failure to take a step, and the step that was not taken was to apply for alternative service, because in these traveller cases, you have to serve proceedings so people can see it on trees or on walls, etc. And there'd be no alternative service application made. And Mr. Justice Nicklin said, you can't use that, it's rewriting history, you can't use CPR 3.10 for something that never happened. So we say that's the position here. And a final point on so the final point on 3.10 is from a case called Ideal and MasterCard, but it goes back to Venus and Marks and Spencer's. It's in the bundle at 26. It's a decision of the Court of Appeal in 2022. What it is saying is that CPR 310 should not be used where it involves overriding or bypassing provisions on the subcode dealing with the service of claim forms. And you'll see that statement at 152.
Paragraph.
152.
It's paragraph 152, page 466. Yeah, sorry, it's 151, 152. And you'll see Sir Julian Flo, Chancellor, says, halfway down, however wide and beneficial the scope of 310, it is to be given in other circumstances than the present cannot be used to remedy a defect in service which is incapable of being remedied by the more specific rules. Here's 6.15, 6.16, since to permit it to do so would involve bypassing those specific rules, contrary to the principle of Venos. And then it said, again, which we rely on, at 152, I consider this much force in what Foxton said in the Serbian Orthodox Church. Rule 3.1 applies to service errors. Rule 3.10 would appear automatically to validate service unless the court ordered otherwise, which, as he said, is a surprising proposition. To permit it to be used in this way would not only contravene the principle in Venos, but it would be contrary to what was said about the service of originating process by the majority of the Supreme Court in Barton. Now, there are specific provisions, we say, which are upset. The apple cart is upset if you proceed as the circuit judge did and treat the N16 form. And the specific provisions are 7.21, specific provision on the commencement of what's taken to commence proceedings. 7.22, the provision that commencement needs an issue date. As a consequence of there being no issue date, 7.5 is also bypassed because the 4-month period of validity goes out the window. Accordingly, the rule 7.6, by which one might extend a period of validity, is also simply not present. At 6.41 is the rule that the claim is generally served by the court, but the opposite position obtains under CPR 23, where it's an application. So confusion was the case in this dispute, we say, because the N16 was never served by the court on the respondent. It's simply included in the bundle for the hearing on the 3rd of August in 2013. And of course, if there's no claim form, there's no response pack, and there's no acknowledgement for service, and then the time limits are thrown into complete disarray because there's no issue date. So a CPR 8 claim is particularly vulnerable to be thrown into chaos unless N208 is used. And the edifice of the procedural rules under CPR 8 are wholly reliant on originating process. The question for the court to decide and the particulars of claim is not forthcoming. If it's not done, there's no abrogation, there's no statement of truth in the in N16A, although except there was a witness statement served also, and acknowledgement of service by a defendant under CPR 8. 3, without service of a claim form, the filing is not triggered and the defendant has not indicated that the claim is contested. So the court is left in the dark as well. All of these things occurred in this dispute, arguably. And lastly, what's happened here is that, in substance, I'm submitting that what's happened is that the circuit judge has made an order for substituted or alternative service by saying what was done on this occasion in July by an N16A is a claim form. Now, there is a specific provision for that, which is CPR 6.15, which allows the court to order that steps already taken to bring a claim form to the attention of the defendant by an alternative method, which in an alternative place is good service. Now, we've just seen that Ideal Shopping, my lady, my lords, makes a very fundamental point at the bottom of page 152, which is to say that one must be very careful not to use CPR 310 to diminish the significance of originating process. So if I can just look at Barton and Wright Hassel, the case is very well known. It's at 18. This was a claim where the claim form was served by email on the last day before expiry, where there'd be no written agreement with the solicitors for email service. That's at paragraph 4. The last, and you see it F on page 244. On the last day before the expiry of the claim form, he emails the claim form and response pack. We rely on what Lord Assumption said at E to F of paragraph 8, page 246, and he said, I'm going to read from CPR 615. He says CPR 615, which is the alternative service provision, that had been relied on by Mr. Barton went for 615. He could, of course, have gone for 310. He didn't. He went for 615. Other cases have pointed out that really what Lord Assumption is saying is equally applicable to both jurisdictions. He says, it is directed specifically to the rules governing service of a claim form. They give rise to...
Where are you?
I'm sorry, I'm on E to F on page 246 of Barton White Hassel. Page 246 on the bundle, and it's paragraph 8, my lord.
Thank you.
It is directed specifically to the rules governing service of a claim form. They give rise to special considerations which do not necessarily apply to other formal documents or to other rules or orders of the court. The main difference is that the disciplinary factor is less important. The rules governing service of a claim form do not impose duties in the sense in which, say, the rules governing the time for the service of evidence impose a duty. They are simply conditions on which the court will take cognizance of the matter at all. Although the court may dispose with service altogether or make interlocutory orders before it has happened, if necessary, as a general rule, service of originating process is the act by which the defendant is subjected to the court's jurisdiction. And it's to similar effect on page 249 at paragraph 16. Although the purpose, this I'm reading from just below E, although the purpose of service is to bring the contents of the claim form to the attention of the defendants, the manner in which this is done is also important. Rules of court must identify some formal step which can be treated as making him aware of it. This is because a bright line rule is necessary in order to determine the exact point in which time runs for taking further steps or for the entry of judgment in default of them. Service of the claim form within its period of validity may have significant implications for the operation of any relevant limitation period, as they do in this case. Time stops running, the limitation period is when the claim form is issued. The period of validity of the claim form is therefore equivalent to the extension of the limitation period before the proceedings can effectively begin. It is important that there should be a finite limit on that extension. An order under 615 necessarily has the effect of further extending it. For those reasons, it's never been thought that the defendant should be aware of the contents of an originating document, such as a claim form. Otherwise, any unauthorised mode of service would be acceptable, notwithstanding that it fulfilled none of the other purposes of serving originating process. And Lord Assumption returned.
How does all of that apply to those cases which, as we looked at earlier this morning, are capable of being commenced by Form N16A?
But you have certainty because you have a rule that says this is originating process.
Yeah.
So I think he's saying, I think he's saying that there's a significance and centrality to originating process. Now, it may be that there are other originating processes under statutes, for example. We've seen the petition, but it is saying that I mean, he's essentially saying the point I just made, that the rules cascade off it. There has to be a moment where the court is seized, and he says that without this obvious step, administrative step, the court is not cognizant of the. I mean, it's Justice Stukenat's point. There is no litigation. And the same is said in Cameron and Liverpool Victoria, which is it's Lord Assumption again on the importance of originating process. It's at 19. This was a case this was a case in which there were problems framing the claim form because it's an unidentified hit and run driver, and the facts are not terribly important, so I'm not going to trouble you with them. What's important are the statements of high principle, which are to be found at on page 268 within paragraph 14. And if I can direct my lady and my lords to just above B, and I'm going to read from there, and I rely on what's said. Court generally acts in personam, although an action is completely constituted on the issue of the claim form, for example, for the purpose of stopping the running of limitation period. The general rule is that service of originating process is the act by which the defendant is subjected to the court's jurisdiction.
Is this the passage you set out in your skeleton?
Yes, it is. Sorry, you've seen it already. That's true. Yeah. 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 The other passages that are of relevance I've sidebarred, which are that the notice period, the notice principle of what the claim actually is, not what the witness statement says it is, but what it's particularised as being is very important. That's at 17. At 18, again, more statements of principle. It would be he's making a point about I think dispensing with claim forms. He says it would be ironic if the English courts were to regard in their own proceedings a principle which they regard as fundamental to natural justice as applied to the proceedings of others. In fact, the principle is equally central to domestic litigation procedure. Service of originating process was required by the practice of the common law courts before statutory rules, and it was introduced following Judicature Acts. The first edition of the rules of the Through Court required personal service. Subsequent editions of the rule allowed for other modes of service without a special order of the court, notably in the case of corporations. Every mode of service had the common object of bringing the proceedings to the attention of the defendant. And again, I just draw your attention to tab 30, another
30.
Tab 30, it's a Travellers' Injunctions decision in Wolverhampton, and at 55, paragraph 55, one sees again more statements of principle as to the bright line. It said service of the claim form is a matter of greater significance. Although the court may exceptionally dispense with service, as explained below, and may, if necessary, grant interlocutory relief, such as interim injunctions before service. As a general rule, service originating process is the act by which the defendant is subjected to the court's jurisdiction, and then again citing Dresser and Barton and Wright-Hassel, and there's significance for many reasons. Yeah. And there's a decision of this court in Patalia, which makes, again, observations of centrality. I'm not going to take you to them because they're really on all fours. But Lord Justice Bean says errors in issuing and serving originating process are in a class of their own. That's at 32 to 37 of the Patalia decision. So a claimant is never lightly relieved of the consequences of invalid or misservice of the claim form under our system of civil procedure. And the outcome is extremely stark for a claimant if service is affected misservice is affected towards the end of the period of limitation, either of the claim form or of the primary limitation period. And the defendant is in fact relieved of defending a claim, a kind of windfall. But policy decisions are made regarding the driving policy force is that the centrality of originating process is of such fundamental importance that the windfall becomes a justifiable proportional benefit to a defendant who's relieved of defending the proceedings. There appears in my submission, this is simply the appellant submits a rare and unusual case, but not a unique case, where a claimant is inviting the court to apply the strictures that apply to service and issue in service of originating process on the facts of the case. It's normally obviously a defendant who would be making the arguments I'm pursuing. There appears to be no reason or principle.
The difference being that it's your responsibility for the fact that the proceedings have not been served. It's your responsibility for the fact no claim form,
Yes,
nothing done.
yes,
at all.
yes. But I'm yes.
But that, assuming there is a power or a jurisdiction to make the thing, do you accept that that is a matter which weighs heavily in the balance of an exercise of discretion as to whether to award costs?
Forgive me, I've not understood the question.
If there's a power, you've accepted that there was a power to make the injunction and a power to set it aside. Power.
Yes, section 38 and section 51.
Just don't worry where it comes from. You've accepted as a power.
Yes.
It's, as I understand your submissions, you're saying that despite that power, there was no power to make any ancillary orders.
No, that's right, because yes, that's right.
My question is simply this: if there's a power to make ancillary orders, do you accept that the fact that you are responsible for the failure to serve a claim form and all the other matters that you've relied upon is a significant matter that weighs in the balance of any exercise of discretion on costs? Can I put it a different way? If the judges below were right as to the extent of their powers, do you criticise their exercise of the powers?
No.
No. Thank you very much.
No, I mean if jurisdictions are engaged, if there's a cost jurisdiction engaged, costs would follow events. I don't think this raises what's happened here. Doesn't raise any. There's no argument that costs don't follow the event in the normal way in this case. My argument is that we just don't get that.
The argument might be whether it's party or indemnity on the facts of the case.
Yes, it's yeah. Again, it's a bridge not crossed yet. But
Yeah,
yes.
understood.
The core there is a core reason and principle we say which is engaged here, which is that no claim form and no proceedings served for claimants is stark and produces disproportionate windfalls for defendants. Taking the objective realities of how that law has, and it is law that favours defendants, but my submission is that that law applies here to these facts and simply produces an unexpected outcome for a claimant. But that doesn't mean that the principles don't apply. Can I just lastly address in the 4 minutes remaining the sympathy? There's a sympathy point here, obviously, understandably, the deserving nature of the respondent to the appeals position. We say there were always mitigating things that she could have done, which were straightforward. It may be that I don't need to trouble you with these because they're in my skeleton argument. CPR 11.6, if I can ask you to bring it up, would appear to be well suited to a situation of the kind that Ms. Perrett was in September last 23. So it's on page 424, CPR 11.16.
Sorry, just to help this, I mean, as I understand it, you've been very assiduous in saying to us how important it is to set aside behaviour context. This is just a matter of pure law that we have to look at.
Yes.
Judges
Yeah.
going through everything you've taken through. So why do we need to start examining if we've not examined how your lay client behaved? Why are you asking us now
Yes.
to examine how the
Yes.
wronged
You
respondent behaved?
The lady's right. The lady's right. These are counterfactuals, which are points that are made in my skeleton. I'm not gonna load them. If I can just scan my notes for just a moment to make sure that there's nothing that would assist you that's in the last page of my note. If I can just make one final point before I sit down. It's to do with the unattractive nature of the proposition, and it was a point made by the circuit judge. You'll recall that in his judgment he posits whether unscrupulous claimants could simply, if my arguments were correct, unscrupulous claimants could obtain gross indulgences and then run away when not face the music effectively. The answers to that are that it would be a vanishingly rare case in which the court is not referred to the contents of CPR 25.9, which if I can just ask you quickly to look at 25.9. This is of course the it's the recast rule, but it's of note. So it provides the requirement that an undertaking to issue the claim form and to consider a cross undertaking for any damages suffered by the respondent should be done. This case was, in my submission, a perfect storm, where the court itself didn't do what it might have done under. If you look at CPR 25.4.
One has to have some measure of sympathy for the deputy district.
Yes, yeah, I'm not.
Even if we're not allowed to have sympathy for anyone,
Sorry,
we might have
25.2.
sympathy for the deputy district judge.
Yes,
Perhaps I might be permitted to have some sympathy for them.
I have total sympathy for the deputy district judge in this case. He was provided with very little to
What
work
was
with.
provided with was wrong,
I'm sorry.
and what he was provided with appears to have been wrong.
I'll just draw your attention to 25.2.4 as being a break, an insurance against what's happened in this case happening, because it provides where the court grants an interim remedy before a claim has been started, it must give directions requiring a claim to be commenced. So this is not an obligation falling on parties, it's falling on the court. And it didn't happen, and the facts are facts, but this is, this is probably a case in a million, is what I'm saying, because there are, at least I hope it would be, there are duties on the part of the parties to put the relevant procedure and law and draft orders, but there's also a requirement on the court to make sure a claim is commenced, to give directions for the claim to be commenced. So this may be a vanishingly rare case. And it's not even this respondent's own case that they would be without a remedy if what I'm submitting is the correct position. Ms. Perrett argued before both the Deputy District Judge and the Circuit Judge that she could bring a separate claim based upon breach of undertaking. and in fact secured permission from the, I don't think permission was needed, but there's a permission recital, it's a permission order in the Deputy District Judge's order, if it was ever needed. So there are other possible forms of remedy available to defendants in these circumstances, short of reinventing the wheel of the CPR.
Do you accept then that your client gave an implied undertaking as to damages?
Well, that's.
I think the answer to the question is no.
No, the answer is that it's Lord Justice Lewison says that's specifically not before the court in his permission to appeal. Our position on that is reserved. It's a position of some complexity, I think, because obviously there's.
In what way do we take account of it?
There may be a difficulty with an implied undertaking that there is an election. The law does have an election element to it, that a claimant can say, well, no, I don't want that duty, therefore I lose my relief, and that. I mean,
I'm terribly sorry to interrupt you, but I don't understand, on the basis of what you've said about this, which is A, you're not giving any accepting implied undertakings damages. B, you say it's all very difficult. I don't understand what we as a Court of Appeal are meant to derive from this submission. What's it got to do with, I was going to say the price of fish, but
you were saying she had an alternative remedy where she would have to rely on an implied.
Well, that's their. I mean, that's been their position all along. I'm just adverting
I
to
don't
it.
think this helps us very much.
Now
you're trespassing now into.
I'll sit down.
Was there anything else?
I'll sit down. No,
Anything else? Anything else? No, thank you very much indeed. You've taken us through complex provisions with great skill. Thank you. Yes, Ms. Fiddley.
My lady, my lords, two judges have so far described the appellant's stance in this appeal as an affront to common sense, that we invite you to be the third, fourth and fifth judges to endorse that view. To the extent that the claimant's appellant's case has any superficial plausibility at all, it's because it exploits ambiguity in too much used legal terms, the term jurisdiction and the term proceedings, terms which, though much used, don't have a consistent meaning across the legal landscape. But once you clear up those ambiguities and identify the sense in which those terms are being used in the present context, common sense returns. It becomes plain and obvious that the court did have the power to make the orders that the defendant was asking it to make in her application of February 2024, and it's plainly right that it should exercise those powers in this case. For the defendant, we're going to structure our submissions under the following 6 headings. First of all, briefly some points about the procedural history. I know you're across it, but there are just a couple of documents I'd like to show you. Second, the meaning of the term jurisdiction. Thirdly, the meaning of the term proceedings as used in the County Courts Act 1984. Fourthly, the meaning of the term proceedings in the CPR. And fifthly, responding to the claimant's arguments based on the irrecoverability of pre-action costs. At that point, I'm going to hand over to Mr. Mitchell, who's going to address you on the alternative ground that His Honour Judge Salmon identified, that's the 3.10 point. So, dealing with my first heading, some points on the procedural history. I don't need to remind you of the litany of errors and abuses engaged in by and on behalf of the claimant that resulted in the wrongful grant of the interim injunction. But can we just look at the application notice that led to that? Tab 1, page 169 in the supplementary bundle. simply make the point that it identifies the provision that's being invoked. It's the Protection from Harassment Act that's being relied upon. You look down at the relief that's actually sought, and that obviously has the smell of defamation about it. But the application is inviting the court to use its powers, which it undoubtedly has under the Protection from Harassment Act, the statutory tort. That application was issued by the court. The court, although it's not on this version, grants the claim a reference number, and the application is served on the defendant. Served short, I should say. It's only served on her on the 1st of August, 2 days before the hearing, but nevertheless validly served. She is aware of it. She attends as a litigant in person, and she submits her own witness statement for that hearing on the 3rd of August. That results, of course, in District Judge Khan's order, which is at tab 8, page 239. That order doesn't record any undertaking to issue the claim form, which the claimant was required to give under what was then the practice direction PD 25A, paragraph 5.1 little 5. It includes no direction to issue a claim form, as the judge ought to have included under CPR 25.2 little 4, the provision Mr. Hurst was just showing you, unless the judge considered that was an inappropriate thing to order. The breadth and vagueness of the injunction itself scarcely needs commenting upon, and the order says it shall remain in force until the next hearing. No further hearing is set. And indeed, when you read down, what the judge seems to have in mind was that there would be a stay for a month, and then some sort of paper process for giving some further directions. So it's an injunction, in effect, of indefinite effect. And as your ladyship's observed, it's hanging over this defendant for 7 months thereafter, while she desperately tries to understand what's gone on as a litigant person, and eventually bring solicitors on board who are able to assist her. That results in the defendant making her own application on the 27th of February, and you'll see that at tab 11, page 275 in the bundle. And you'll see what it's seeking. It's seeking a variation to include cross-undertaking net of damages. It's seeking revocation of the injunction. Seeking to have the claimant's application as certified as totally without merit. Claiming damages through the operation of the undertaking. And claiming costs. Now, my learned friend this morning described this application as one for wide-ranging relief, engaging the full panoply of the civil procedure rules. We beg to differ. This is a focused order, a focused application aimed at inviting the court to take steps to undo the havoc that's been wreaked by the injunction. It goes no further than that, we say.
And the purpose of paragraphs 1 and 2 being in that order would be that if you first get the order the injunction changed to include an undertaking for damages, and then you revoke it, you can rely on the undertaking for damages for your damages.
That's clearly the thinking
That's
behind
the thinking,
it, yes.
Yeah, neat.
So that application then comes on before Deputy District Judge Robinson, who makes his order on the 29th of April, sealed on the 7th of May. You'll see that in the core bundle at tab 14, page 141. and you'll see there's a lengthy recital recording the fact that the claimant is submitting the court is not seized of any claim and has no jurisdiction, but nevertheless does agree that the injunction can be discharged.
How does that work?
Well, this is one of the contradictions at the heart of the claimant's case. The court has powers when he wants it to be used and doesn't have powers when he doesn't want it to be used. But because that issue's been raised before the Deputy District Judge, his order starts with paragraph 1, that it is declared that the court has jurisdiction to hear the defendant's application. That's the application we just looked at. Then at paragraph 2, the injunction is discharged. Paragraph 3 includes a direction, builds into a direction for the 3rd of August requiring the claimant to issue a claim form. In paragraph 4, in default, if the claimant doesn't do that, giving permission for the defendant herself to issue a claim seeking costs and damages. And I think it's common ground between us that that is a permissible step a person in this situation can take. That's covered by the authority of Associated Newspapers Limited and IMPAC, which I'll take you to in due course for another point. And then directions are given, costs reserved. That then, as you know, goes on appeal to His Honour Judge Salmon. You'll see his order at tab 5 of the core bundle, page 68. That order sets aside most of the operative parts of District Judge Robinson's order and instead makes directions for the costs and damages matters to be dealt with. You see that in paragraph 6, listing a directions hearing to make directions for the determination of the remaining issues of damages and costs of an incidental to the interim injunction. And that is, in effect, where things have reached now. I don't know if there's a formal stay in place or not, but matters are not progressing until we hear this court's response to this appeal. So that's the relevant procedural history. My next heading is the use of the term jurisdiction, and I think I'll be able to get through this before the short adjournment. The key authority on this, we say, is Fourie and LaRue, which is the Supreme Court or the House of Lords authority. Tab 10 of the authorities bundle. You can get the facts from the head notes. There's a without notice application made for a freezing order by the liquidator of 2 South African companies against 2 English domiciled individuals. The first instance judge grants that order, even though at that stage no claim had been issued, and indeed the claimants probably didn't intend to issue in England because they were intending to take substantive proceedings in South Africa rather than in England and Wales. And as was observed, the claimants didn't put forward any formulation of the relief that they would be seeking in a substantive claim. And then the important holding is holding 1 in the head notes. A court had jurisdiction in the strict sense to grant an injunction where it had in personam jurisdiction over the person against whom it was sought, and that a freezing order might in suitable circumstances be granted and served on the respondent before substantive proceedings had been instituted, although the judge should pay careful attention to the substantive relief which was or would be sought. That head note is drawn from the discussion of Lord Scott. And the important passage begins at paragraph 25 in his judgment. It says, both the Deputy Judge and Sir Andrew Morritt, Vice-Chancellor, referred to the issue as one of, quotes, jurisdiction, but jurisdiction is a word of some ambiguity. The ambiguity was referred to by Lord Justice Pickford in the Guaranteed Trust case. From that, he quotes, at the first, in my opinion, the only really correct sense of the expression that the court has no jurisdiction is that it has no power to deal with and decide the dispute as to the subject matter before it, no matter in what form or by whom it is raised. But there is another sense in which it is often used, i.e. that although the court has power to decide the question, it will not, according to its settled practice, do so except in a certain way and under certain circumstances. And having identified that distinction, Lord Scott goes on to find that the judge at first instance here did have jurisdiction in the strict sense. This is still in paragraph 25. Both were within the territorial jurisdiction of the court at the time the freezing order was made. Both were shortly after the freezing order had been made served with an originating summons in which relief in the form of the freezing order was sought. No challenge to the propriety or efficacy of service on them. And he returns to the point at paragraph 30, having gone through some authorities, he says these show, in my opinion, that provided the court has in personam jurisdiction over the person against whom an injunction, whether interlocutory or final, is sought, the court has jurisdiction in the strict sense to grant it, but then whether it should exercise that jurisdiction and grant it in the particular circumstances covered by judicial precedent. And the last point to make is at paragraph 32 over the page. By little g, not in dispute that in suitable circumstances a freezing order may be and often is granted and served on the respondent before substantive proceedings have been instituted. Such an order is not a nullity. It is of immediate effect. If proceedings for substantive relief are not instituted, the freezing order may lapse in accordance with their own terms, or in the application of the respondent may be discharged, but none of this indicates that the court had no jurisdiction to make the order. No activation of the jurisdiction is needed. And we say that's the position we're in here, that there was a dispute brought before the court by the claimant that the court had power to deal with, its powers to deal with harassment claims at least. That the court office has issued the injunction, allocated a reference number to it. It's been served on the defendant, so we're in a stronger position than Florian and LaRue, where no service of anything had taken place at that stage in the normal freezing order situation. Here she's been served, albeit a short service. She's before the court and she's disputing the application that's being made. So we say three things flow from that, and two of them my learned friend and I are agreed upon now. First of all, the court did have power to grant the injunction. That's expressly accepted by Mr. Hurst. Let's see paragraph 29 of his skeleton. He's no longer saying that this was a nullity or there was no jurisdiction in the strict sense. Secondly, the court had power to discharge the injunction. Again, the parties are agreed. That same paragraph in Mr. Hurst's skeleton. It's on the third point that the parties diverge. Did the court have power to make the ancillary orders? That was a term used by Lord Justice Stuart-Smith in talking to Mr. Hurst this morning. We say it's an apt term for what we were seeking in our application of the 27th of February. Did the court have power to make those ancillary orders requiring the claimant to issue a claim form or giving the court power to award costs or damages sustained by reason of the unjustified grant of injunction? And we say yes, it simply follows from the same position as the first two questions. The court has jurisdiction in the strict sense. The claimant has put forward no principal reason why, having said yes to the first two questions, he now says no to this third one, except that it doesn't suit him. Now, Fourie and LaRue was a case that came from the High Court, and so the Supreme Court, the House of Lords there was addressing the High Court's inherent powers. And there's no need to turn it up, but in the recent Supreme Court case, the Wolverhampton case concerning injunctions, it's again confirmed that subject to any statutory restrictions, the High Court's power to grant injunctions is unlimited, and indeed doesn't even depend on the existence of a cause of action. But in case it be suggested there's some difference between the High Court's powers in this situation and the County Court's powers, see section 38 of the County Court Act, Authorities 31, page 607. You've seen this before, but 38.1 says, subject to what follows, in any proceedings, and I place reliance on those words, the court may make any order which could be made by the High Court if the proceedings were in the High Court. So the High Court's inherent powers that are then recognised in Supreme Court Act section 37 that then come down to the County Court through this statutory provision. But it's a power to make orders in any proceedings. There have to be proceedings before the power to make orders arises. And note, and this is one of the paradoxes of the claimant's position, the claimant's accepting that the County Court did have power to make the order for the injunction in the first place and did have power then to discharge that injunction. So you must also be conceding that those orders were made in proceedings before the County Court. So that brings me on to my third heading, what the meaning of proceedings is in this context. Would you like me to start for a few minutes, or shall I resume at 2 p.m?
How are you doing for time overall?
I'm doing well. I will be done by. I can't put a precise time.
No,
on it,
no,
but
I
I'm
wouldn't
ahead
ask
of where
you
I
to.
hope to be.
Well, in that case, we'll rise now and sit in at 2 o'clock.